Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There is no proof Mr. Kohberger will appeal his sentence based on what happened yesterday to change the law on appellate waivers. There is no possible way to know until he either appeals or does not appeal with this new miscarriage of justice standard, now the law of the land uniformly across the country. There is some information that SCOTUS gave us as to what rises to the level of miscarriage of justice. This decision, it's not just between the parties, but it's the judiciary that's at issue here. The judiciary has to, if there is an appeal filed, look at whether or not the appeal waiver should be set aside. Page 4 of Hunter versus United States reads, "The miscarriage of justice standard sets a high bar. The waiver may be set aside only if the sentence is marred by the kind of egregious error that would bring the judicial system into disrepute. The error must be obvious, not one a judge could reasonably make, and must be of the type that would undermine public confidence in the judiciary." Paragraph 2, page number 4. "The nature of the miscarriage of justice limit precludes any attempt to list all of the situations in which it will overcome an appeal waiver, but a few examples of the kind of errors that would bring the judiciary into disrepute may provide guidance to lower courts. 1. A sentence exceeding what the relevant statute allows. 2. A sentence infected with a blatant non-constitutional error, such as when a judge takes into account a constitutionally impermissible factor like race, or imposes a constitutionally infirm condition of supervised release." And then, ladies and gentlemen, a sentence imposed without some minimum of civilized procedure. These examples are just examples, not intended to be exclusive, but they may serve to illustrate the high bar a defendant must surmount to overcome an appeal waiver. A high bar, but not an impossible bar, ladies and gentlemen. It would be up to the defendant who signed the appeal waiver to bring forward facts, such as a sentence imposed without some minimum of civilized procedure. What happened in the Kohberger case from start to finish in the more than 2.5 years that it proceeded is largely something that the public does not know because, number one, so many documents were sealed from the public, and they are still sealed today, a year nearly since change of plea. And because of all the hearings that happened in the case that were sealed from the public, some of them weren't even noticed, such as at the very beginning of the case, when there was a concern that there might have been a conflict of interest in defense counsel representing Mr. Kohberger. There was a hearing. No one knew about it because it wasn't noticed. The non-dissemination order, which also helped to lend to the secrecy of the case. We will learn, undoubtedly, in the days, weeks, perhaps months to come, if Mr. Kohberger decides to appeal his sentence, if and only if he files a notice of appeal. It is a decision that Mr. Kohberger and Mr. Kohberger alone is authorized to make. Hunter versus United States is the new law of the land, effective June 18th, 2026. It's a case we have been following and you have been following for a very long time. If you have not had an opportunity to read the opinion, it's not that long. There are over 60 pages, but most of them are the concurring opinions or the sole dissent. The majority opinion, the one that counts, is the first 5 pages. Please read it. Until next time, this is Kathy. Thank you for joining us here today.